Francis has talked very powerfully, I thought, and compellingly about the reforms that have taken place and are taking place in the youth justice system, the achievements and some of the challenges that lie ahead, to which the Youth Justice Board in particular is supporting local partners and working with the government to rise to. I will focus more, therefore, on the role of probation services and wider partners in the criminal justice system to reduce reoffending and reduce crime. And so the fundamental point that I want to make in talking about some of the reforms that we are introducing at national level in government is that none of those will work unless we can work with you, partners in the police, in courts, with judges and magistrates, with prosecutors and defence practitioners, right the way through the court system and to probation and prisons in order to reduce crime and reduce reoffending. So nothing that I talk about will work without that. And my Minister, Crispin Blunt, will be telling you more later about these reforms, but I want to give you some flavour of them now so that I can tell you about the context within which we're supporting local partners to work. I wouldn't be able to steal Crispin Blunt's thunder even if I tried, because he will be able to do it much better than me, and you will have plenty of chance to ask him questions about it. Let's start, though, by saying a little bit more about the context within which we are working. So, first of all, we have to remind ourselves that until quite recent years, spend on criminal justice and on most parts of the criminal justice system went up. Demand on most parts of the criminal justice system also went up. So Francis has highlighted the fall and the sustained fall in young people coming into the justice system for the first time, and the fall in the number of young people in custody. That is not reflected among adults, as most of you here well know. So the probation caseload has risen, the prison population has risen, numbers in the courts have remained, for the most part, pretty static, although there have been some rises in recent years in the number of defendants going through the Crown Court, and some falls in the number of people in the magistrates' courts. So some changes, some falls, but largely there has been an increase in demand. There have been some achievements in respect of reoffending. So, for instance, since the year 2000, there has been a 1.6 percentage point fall in the proportion of people, adults, who reoffend. And Francis highlighted the fall in the number of offences committed by young people. And both of those things are important. Both of those things should be highlighted. And partners in probation and wider partners have contributed to those falls. There is still a very long way to go. So people coming out of custody, at least half of them reoffend, and for some of the shorter sentences, under 6 months, it's much higher than that. We're also working in a context in which, as we know, and by any published studies, offenders have a range of complex needs. So a very large proportion of men and women who offend have mental health needs, have drug and alcohol addictions. There are many who have learning difficulties. There are issues about literacy, reading and writing, and so on. So we are operating with quite a complex group of offenders. And that means that all of us here have a challenge in doing better on reducing their offending. We also know quite a lot more about who those offenders are. And I take opportunities at the moment, I have to say, unashamedly, to big up our analytical teams in the Ministry of Justice and working with the Home Office and other government departments, because I think we're pretty pioneering in our increasing knowledge of reoffending rates, of the comparisons between different sorts of sentences and their effectiveness, of linking, for instance, information about benefits with information about offending. So during the riots last summer, we were able to link justice data with Department for Work and Pensions data on benefits, and that tells us a lot more about the characteristics of offenders. And this is the sort of thing that will enable us to have a much better targeted approach, working across government and giving that information to local partners who do the job to reduce crime and reoffending on the ground. We published a whole compendium of information on reoffending, as well as our general quarterly and national statistics. So we published that compendium at the end of 2010, and you can access it on our website. That compares, just for instance, the effectiveness of community sentences and short custodial sentences. And for the first time, it controls for the differences between the sorts of offenders that might get a community sentence versus a short custodial sentence. So it means you can draw some conclusions and be reasonably confident in doing so, that you are comparing like with like. So one of our big contextual reforms is we've got a complex group of people, we've got some achievements in reoffending, but a very long way to go, but we know a lot more about who's reoffending, we know a lot more about the sorts of needs they've got, and we know a lot more about the sorts of things that work, and we're trying to put it out there for people to use. We can go further, and we know we have to go further, so we know we need to go further in putting the what works information out there, and that will enable our big focus on outcomes to happen. I'll go on to talk a bit more about wider reforms now that I hope will provide the enabling framework for all of us to do still better. So, first of all, we're trying to improve the clarity, transparency, readiness to interpret of the sentencing framework. So in the Legal Aid Sentencing and Punishment of Offenders Bill that is before Parliament at the moment, we are, for example, trying to bring everybody onto the same sentencing framework so that there isn't confusion about what sort of release date you get depending on when your offence was committed. We are making some changes to the duty to explain sentences for judges and magistrates so that you, if you're here, can better use your own professional judgment to tell offenders, victims, the public, wider society, what the sentence is and what it means, instead of having a very long list of complicated tick-boxy requirements that you have to use. We hope that that will improve understanding of sentencing, together with, for example, what the Sentencing Council is doing to better communicate. We're doing a number of things that we hope will make the requirements of the community order, as well as, for instance, out-of-court disposals, more readily able to be used, and for sentencers and probation officers in their recommendations to have better choices of packages that might be combined in order to reduce reoffending and punish offenders more effectively. One example of that is that we're trying to make it easier to use the treatment requirements, so the drug, alcohol and mental health requirements in the community order. We're trying to make it easier to be able to recommend those for use, and that, we hope, will help probation officers in the choices that they're giving. We're making some changes to electronic monitoring, tagging, so that, for instance, somebody can be under curfew for a longer period of time during the day and over 12 months if necessary rather than 6. Not so that, you know, people can use curfews 24 hours a day, but so that they can be used a bit more imaginatively, both to punish and to support somebody's rehabilitation. All of this is important to the criminal justice system as a whole. I think it's pretty important to probation because probation are much of the time advising and recommending to sentencers what sorts of packages in the community order might be chosen. And there's a pretty high concordance rate between what probation officers propose and what magistrates and judges go for. So being able to have those choices, being able to combine in the ways that they think right, and making sure that those requirements are available to people in the community is obviously important. Linked to that then, we are supporting liaison and diversion services for people with mental health needs throughout the criminal justice system. So that includes, for instance, practitioners, nurses in custody suites, so that if appropriate, offenders, defendants may be diverted from the criminal justice system altogether. It may be that a decision is taken to use a conditional caution, where the condition might be some engagement with an activity or some treatment. If you get to the stage where you're in court, we have practitioners in court as part of liaison and diversion, so that people again can access treatment, or, for instance, the specified activity requirement of the community order, where then you might also be able to engage with some voluntary sector practitioners who will support you with your mental health, drug and alcohol needs, and learning disabilities. I was in Sussex recently, in Brighton, and I visited the custody suite and saw the risk form that they're using to help people access liaison and diversion services. And I talked to police and probation officers and youth justice services, and I was pretty impressed by the thinking that's going on about this and the impact that those practitioners think that this can have there. So that's some of the sort of stuff that we're doing there. We're also trying to ensure that probation officers and wider practitioners can use their professional judgment in order to decide how to deal, for instance, with breach and enforcement of community sentences. So that means, through the changes that we're making to national standards for probation, being able to use your judgment more in deciding what is unacceptable, but still ensuring that when you have decided that something is unacceptable on a community order, enforcement action is taken, and it's very clear that that enforcement action is taken. So nothing here that should undermine public or sentencer confidence in community sentences, but changes that do enable probation officers, offender managers, and others to use their professional judgment. Some changes, similarly, that enable sentencers to use your professional judgment. And there, we're building on some of the lessons from the Surrey and Sussex pilot. So Kay from the Cabinet Member for Community Safety may know about the pilot where we tried out how we can enable probation officers and others to better use their professional judgment. A second reform that runs right across everything that we are doing is a much stronger focus on outcomes. Most of you will have heard about payment by results, and there may be complexities in the payment mechanisms and all the rest of it for payment by results and how you measure reoffending. But in the end, what it's about is focusing on the end outcome that matters, the reduced reoffending, the getting people into work, the getting people off drugs. And so it's a means to an end. It's a means, again, to reducing reoffending, to better stopping crime and keeping the public safer. We've got quite an ambitious pilot programme going on, which Crispin Blunt will talk a bit more about. Some of you will be familiar with it. So, for example, we've got the social impact bond pilot with prisoners being released from Peterborough Prison, having served sentences under 12 months, and we've got a range of voluntary sector partners, including St Giles Trust and the Ormiston Children and Families Trust, working with those offenders to prevent them from reoffending. This is pretty important because this is a group of people who get no statutory supervision on release and whose reoffending rates are high, as many of you will well know. We've got the pilot with the private sector prison in Doncaster, where we've put 10% of the contract price at risk, the 10% that focuses on reoffending, and the providers get to keep a proportion of that if they reduce reoffending by at least 5 percentage points. And it's capped, and I won't go into all the, again, the complexities of it, but broadly that's what it's about. It's about incentivising that focus on outcomes. We have announced 2 probation trusts who will work in partnership with private and or voluntary sector providers in order to have a payment by results pilot, and those are in Wales and in Staffordshire and the West Midlands. And now that we've announced those trusts, we're working with them to help them develop their pilot approach and find the partners with whom they'll do their joint ventures. Important to say, I think, that this focus on outcomes, this payment by results, is about all sectors, so public, private and voluntary. We are seeking to introduce greater competition into offender management services. We want the focus on outcomes to be right across the piece. We can't transfer risk through a payment by results approach within the public sector, so that's why we're looking at sort of joint venture type models, and we've got a payment by results approach with Highdown Prison as well as with Leeds Prison. But we are also looking at what does that focus on outcomes mean in the public sector. And we're now working on our implementation strategy for payment by results across the offender management system by 2015. And so making sure that we can apply this across all sectors is an important part of that strategy. It's given me a chance to say a little bit more about the sort of partnership approaches that link with payment by results.
Briefly, Helen.
So, apologies, yes, I'll be brief. Francis mentioned the youth justice pathfinders that we've got going. We've also got justice reinvestment pilots in Greater Manchester and in 5 London boroughs. And these are about all the local partners, police, probation, others, working together to reduce demand on the criminal justice system, but basically reduce crime, reduce reoffending. I visited the partnership in Manchester and was really impressed by how they are setting out at each part of the system what they're going to do something better with that group of offenders. And thinking about what Abdul was saying there from Camden, they're linking that with their troubled families agenda. So they're thinking about how can they work not only with the group of people who are already in the justice system, but with the troubled families. They're also using their integrated offender management approach, and there we have lots of examples of police, probation and others working effectively together to bear down on and rehabilitate some of the most prolific offenders, and we want to support more of those sorts of approaches. Similarly, at the more serious end, we've got the MAPA partnerships that are, broadly speaking, working very well, and again, we want to continue to support them. So that means that with the advent of police and crime commissioners, it's very important to us to work with the Home Office in the events that they're doing at the moment right across the country on how the duty to cooperate will work in the Act, how local partners will work together right across the system to reduce crime and reoffending. You would probably think I was remiss if I didn't mention the fact that we are, of course, working at the moment on a review of probation, and will shortly be publishing a consultation document on that subject. I know that many of you are keen to see that appear, and I hope you will see it before too long. I can say, without preempting it, that the sorts of reforms I've talked about this morning will be reflected within it. So we've achieved lots, we have lots more to do. I hope that gives you a flavour of the sort of framework that we're trying to provide to enable you to work within. Thank you.